Okay, in these presentations, I am presenting on the topic confessions and distinction between the judicial confessions and extrajudicial confessions. From sections 24 to 30 under the Indian Evidence Act, we have to see it is. Here, at first, the basic concepts of the confessions. Here, confessions, it is a statement made by an accused person charged with a crime in criminal proceedings. That is, here, if the accused person confesses himself about the commission of the crime, about his guilt, then it comes under the concept of the confession. You have to remember about it. That is here. Now the related provisions of the confessions. It is expressly given from sections 24 to 30 under the Indian Evidence Act 1872. Here, now the related provisions we are discussing one by one. Now, section 24 at first. Here, section 24 it provides about the confession caused by inducement, threat, or promise when irrelevant in criminal proceedings. This section provides about the confessions under the influence of the inducements, threat or promise when it will be relevant and when it will be irrelevant. That is here. This section reads as a confession made by an accused person is irrelevant in criminal proceeding if the making of the confession affairs the court to have been caused by any inducement, threat, or promise having reference to the church against the accused person proceeding from a person in authority and sufficient in the opinion of the court to give the accused person grounds which would appear to him reasonable for supposing that by making it he would gain any advantage or avoid any evil of a temporal nature in reference to the proceeding against him. Here, concept of the induced confessions. It is given expressly in the section 24. Here, if there is the concept of the inducement, threat, and the promise by the persons in authority, that is the police officers. Yeah, then it will be the confessions of the accused persons will not be relevant, and it cannot be used as an evidence in the court proceedings. Here, now the induced confessions concept. Here, the conditions of irrelevancy under this section are under the some conditions, under the some circumstances. It comes under the concept of the induced confessions. Then it will be relevant. When it comes under the concept of the induced confession, then it could not be relevance regarding the facts in issue and disputed facts on which the prosecution is conducted in the criminal prosecution. Here, number one conditions under which the confessions will be induced confessions. Number one, the confession must be the result of inducements, threat, or promise. That is, and number two, inducements etc. should proceed from a person in authority. And whatever the induced confessions, it must be proceed from the persons in authority. That means it may be the police officer, it may be extorted by the police officer, or it may be by some authority which are empowered by the court. That is, then it comes under the concept of the induced confessions, and it should relate to the search in questions. And whatever the induced confessions, it must be related to the relevant facts in issue and disputed facts under which the prosecution is conducting on before the court. And number four, it should hold out some worldly benefits or disadvantage. Yeah, and whatever the confession made by the accused persons, yeah, the prosecution side, they must gain some advantage and a disadvantage to the accused persons. Yeah. Now, when these conditions are present, whatever we have discussed the conditions for the induced confessions, if these conditions are present, the confession is said to be not free and will not be receivable in evidence. Under these conditions, it comes under the concept of the induced confessions, and it could not be received as evidence in any criminal prosecutions against these persons. It is here. Now, the section 25 here. Confession to police officer not to be proved. Yeah. Section 25 expressly given them whatever the confessions before the police officer, it cannot be proved in the judicial proceedings. It is expressly prohibited that it is not an evidence. It cannot be proved in the criminal prosecution. Here, now the section 26. Here, a confession by accused while in custody of police not to be proved against him. Here, next section provides section 26 provides about it. Whatever the confessions by the accused persons in front of the police officer, it cannot be proved. While the accused person in the custody of the police officer, and if he made a confession before the police officer, it cannot be proved against him. But one condition is given here. But if the confession by the accused persons is made in the immediate presence of the magistrate, then the confessions of the accused persons can be proved against these accused persons, and it can be used as evidence in the court proceedings against these persons. Yeah. Now the section 27. Here, how much information received from accused may be proved. Yeah. It says about the information, whatever the police officer court discovered from the accused persons. It is a help in the discovery of the fact distinctly to prosecute the case. Then it will be used as an evidence. That is, Yes, section 27 expressly given about this. Yeah, what about the confessions? To the relevant fact, if it is useful for the discovery of the fact clearly by the prosecution side, then it can be relevant and it can be used as an evidence. Section 27 provides about this. And this section here under the Indian Evidence Act, there are two situations in which confessions to police are admitted in evidence. Yeah, you have to remember about this. Under which situations confessions to police officers can be admitted in evidence. That is, here number one conditions when the statement is made in the immediate presence of a magistrate, and secondly, when the statement leads to the discovery of a fact connected with the crime. That is, when the statements leads to the discovery of the fact connected with the crime. Under these conditions, whatever the confessions by the accused persons before the police officer, it will be receivable as an evidence in the court. We have to be remembered that is these two concepts. Number one, in the immediate presence of the magistrate, if the accused person has confessed before the police officer, and secondly, whatever the confession made by the accused persons, if it is helpful in the discovery of the fact in connection with the crime. These two distinct concepts you have to be remembered regarding the confessions. We have to be very clarified about these two concepts. Here, now this section 28 here, this section provides a confession made after removal of impressions caused by inducement, threat, or promise relevant. Here, section 28 expressly given that. Section 28 expressly given that after the removal of the impressions caused by the inducement, threat, or promise, then the confession made by the accused persons will be relevant. Yeah, if the police officer or the court, they have been taken confessions after removing the inducements or threat or promise, then under these conditions, yeah, the confessions of the accused persons will be relevant, and it could be receivable as evidence in the court. Now the section 29 here, confessions are otherwise relevant not to become irrelevant because of promise of secrecy, etc. Yeah. The effect of this section is that a confession is relevant if it is obtained under the some circumstances. Here we have to see by making a promise to the accused that it will be kept secret or that evidence of it shall not be given against him. Here, such confession is not relevant in civil case under section 23. The policy being that litigants should be encouraged to compromise their differences. Here, under the concept of the promise of secrecy, here If the persons in authority, they have assured state, whatever you will make the admissions and statements regarding these facts, for the settlement under the compromise, then this will not be produced in the further proceedings in the court. Yeah, the concept of this is that to encourage the litigants for the settlement of disputes and to prevent the multiplicity of the proceedings before the court. Yeah, but this concept of diplomacy is not applicable in the criminal prosecutions. It is depends on the public interest that the law and order should be controlled, that the crime should be controlled, that the perpetrator should be punished, and give example to the society. That is, under this concept, whatever the confessions obtained by the authority under the secrecy, that whatever the accused persons will give confessions, it cannot be produced as evidence. This concept will not be applicable. Yeah, under the concept of the secrecy, the persons in authority, they can be extorted and can be receive evidence in the criminal prosecution. Here, now by practicing a deception on the accused for the purpose of obtaining his confessions. Yeah. Number two concept, by obtaining confessions by deception and on the accused persons. Yeah. If the authority, that is the police officer, if they have been confined the two accused persons in a room under the surveillance of the tape recorder, in these cases, whatever the accused persons, these two accused persons, they have made conversations with each other, they have discussed, they have made statements, conversations with each other. Then, whatever they recorded under the tape recording of these two accused persons under the concept of the deceptions by the authority. Now, this can be used as an evidence, used as a receivable evidence in the criminal prosecutions. That is the basic concept of this section 29. Confession otherwise relevance, not to become irrelevant because of promise of secrecy. Yeah, we got the clear concept. Now the last sections of confession, that is the section 30. Yeah. Section 30 expressly given considerations of true confessions affecting persons making it and others jointly under a trial for a sham offense. Yeah. Section 30 provides about the confession of accused persons who have been jointly tried for the sham offense, for the commission of the sham offense and sham prosecutions, if they have been jointly tried in the sham offense. Here, these sections are provided if the confession by one of the accused persons, if it is affecting the interest of these accused persons, and the court has taken the considerations, if the court has established that this person has actually committed the crime, then these considerations of the confessions by this particular accused persons can be used as an evidence against the other co-accused who have been trying in the sham offense jointly in the criminal prosecutions. Section 30 provides about this. Here, one illustration you could see here, A and B are jointly tried for the murder of C. Here, it is proved that A said B and I murdered C. Hmm. Here, A confessed that B and I murdered C. Now, the court may consider the effect of the confessions against B. Now, whatever the confessions for the commissions of the crime established by the court against the A, it can be used as an evidence against the B. That is, here, up to this, we have discussed the related provisions of the confessions under the Indian Evidence Act. Now, the distinction between the judicial confessions and extrajudicial confessions. Here, judicial confessions are those confessions which are made before a magistrate or in court in the due course of legal proceedings. That is, a judicial confession has been defined to mean the plea of guilty on arrangements made before a court if made freely by persons in a fit state of mind. Here, under the concept of the judicial confessions, it comes the statements by the accused persons before the magistrate. Here, the concept of the guilty pleas. These are the judicial confessions. Whatever the accused persons, they have pleads they are guilty. It comes under the concept of the judicial confessions. If they are made freely, and if they are in a mentally fit, in a fit state of mind. That is, that means after the removal of the inducements, threat, or promise by the persons in authority. It may be police officer or it may be by the court. Here, now the extrajudicial confessions here are those which are made by the accused elsewhere than before a magistrate or court. Here, it is not necessary that the statements should have been addressed to any definite individual. It may have taken place in the forum of a friar. It may be a confession to a private person. Yeah. The extrajudicial confessions, it means that outside the court or outside the police officer. It may be the confession before the private individuals, or it may be outside the concept of the persons in authority. Here, this concept comes under the extrajudicial confessions. That is. Here, section 164 of the Criminal Procedure Code. Here, these sections made the distinction between the judicial and extrajudicial confessions. Based on this section 164 of the Criminal Procedure Code. We can clearly distinguish between the judicial confessions and extrajudicial confessions. Based on these sections, now judicial confessions are those which are made to a judicial magistrate under section 164 of the Criminal Procedure Code, or before the court during committal proceeding or during trial. Here, on the other hand, extrajudicial confessions are those which are made to any persons other than those authorized by law to take confessions. It may be made to any persons or to police during investigations of an offense. That is, here to provide judicial confessions. Number two distinctions. To provide judicial confessions, the person to whom judicial confession is made uh, need not be called as witnesses. Here, at first you remember that whatever the judicial confessions made before the persons in authority, it may be before the police officer or it may be before the magistrate. Here, the persons made the confessions need not be called as witnesses. Yeah, it is the established confessions. It is the direct confessions who are made under the before the police officer in the immediate presence of the magistrate, or at the moment of the proceedings of the court, if the accused person given confessions, it is the established fact, it is the established evidence. That's why the persons who made the confessions, it need not be called as a witness. Yeah. The further examinations of these witnesses is not necessary. That's why the concept of the guilty plea we got. If after removing the inducement to the promise, the magistrate has taken the confessions, then it is directly used as an evidence under these prosecutions related to the relevant facts and disputed facts on the prosecutions. Here, but extrajudicial confessions are proved by calling the person as witness before whom the extrajudicial confessions is made. Now, in case of the extrajudicial commissions, here, who are made by the accused persons outside the police officer or magistrate, here, before whom the accused person made confessions, these persons can be called as witnesses and examined by the court. It can be cross-examined before the court proceedings. That is, but in case of the judicial confessions, whatever the confession before the police officer in the immediate presence of the magistrate or before the court proceedings, further examination is not necessary. It is a direct establish of the confessions by the accused persons. Now the number third distinctions. The judicial confession can be relied as proof of guilt against the accused persons if it appears to the court to be voluntary and free. Here, if the court is of the opinion, if the accused person has confessed voluntarily and freely, then it can be used as an evidence, receivable as evidence in the criminal prosecutions. But extrajudicial confessions alone cannot be relied. It needs support of other supporting evidence. But the extrajudicial confessions, it cannot be relied directly. It cannot be relied. It cannot be relied alone. Here, under independent evidence, under circumstantial evidence, it must be observed by the court. That is, it must be taken consideration by the court, by the judiciary, in case of extrajudicial confession. That is, and number four distinctions. Here, a convictions may be based on judicial convictions. Here, if the accused persons made confessions before the magistrate, before the court, then based on this confession, based on this statement by the accused persons, here conviction can be given to the accused persons. Yeah, sentence of convictions can be ordered if it is established that the accused person has actually committed the crime. And on the other hand, it is unsafe to those to base conviction on the extrajudicial confessions. But in case of the extrajudicial confessions, it cannot be directly convict the accused person based on these statements. Yeah, some independent evidence, some circumstantial evidence must be examined by the court, must be examined by the judiciary. That is, here we have got a clear concept, the distinction between the judicial confessions and extrajudicial confessions based on section 164 of the Criminal Procedure Code. Now, the evidentiary value of the confession. Here, in case of the judicial confessions, here, a case where there is no proof of corpus delicti must be distinguished from another where that is proof. In the absence of the corpus delicti, a confession alone may not sufficient to justify convictions. If it is directly established that the accused person has actually committed a crime, then conviction can be led to this accused person who ever confessed. Yeah, a confessional statement made by the accused before a magistrate is a good evidence, and accused be convicted on the basis of it. Here, a confession can be obviously be used against the maker of it, and is in itself sufficient to support his conviction. That is, yeah. Now the settled law is that a conviction can be based on confession only if it is proved to be voluntary and free. Yeah, we have already discussed. If the confession by the accused person is voluntary and free, if it is done by the police officer and the magistrate who are the persons in authority, after the removal of the inducement, trade or promise, then the confessions whoever extorted from the police officer, whoever extorted from the accused persons, these have the evidentiary value. That is, it can be receivable as evidence. That is, but in case of the extrajudicial confession, now the evidentiary value of the extrajudicial confessions here. The evidence of extrajudicial confession is a weak piece of evidence. Here, the extrajudicial confessions must be received with great care and caution. It can be relied upon only when it is clear, consistent, and convincing. The court has to decide whether the persons before whom the admission is said to have been made are trustworthy witnesses. Yeah, In case of the extrajudicial confessions regarding the evidentiary value, here, whether the confession by the accused persons has been given to such a persons, whether these persons, when calling as a witness in the court, whether he is a trustworthy or not, whether he could be reliable or not under the relevant facts in issue or disputed fact under which the prosecutions had been held. In these cases, the judiciary has at first ascertain it should be clear, and it should be with very care and cautions. Judiciary court or a magistrate or justice, they have to see very cautiously. They have to follow the rule of cautions, that is. And another basic concept, retracted confessions. Here, a retracted confessions is a statement made by an accused person before the trial begins, by which he admits to have he admits to have committed the offense, but which he repudiates at the trial. Now, another concept, retracted confessions, you have to be known. Such confessions by the accused persons are known as retracted confessions, which are made by the accused persons before the trial. But at the moment of the trial, he denied, he rejected the truth of whatever he made statements before the prosecution of the case. That means contradictions with the two statements before the prosecution of the offense before the court, and after the prosecution, after the trial has begins in the court. If these two statements by one accused person is contradicted with each other, then it comes under the retracted confessions. You must have to be clear about it. Retracted confessions. Whatever the accused persons, he made confessions before the trial is held. But after the prosecution of the offense, he has repudiated such confessions. Whatever he made statements, he denied that I did not make such statements. That is, he rejected truth of his own statements. Whatever he previously made before the prosecution has been held by the court. That is the concept that is the concept of retracted confessions by the accused person himself. Here, after this, we have been clearly discussed about the concept of the confessions and the related provisions of the confessions under the Indian Evidence Act from the sections 24 to 30, and distinction between the judicial confessions and extrajudicial confessions based on section 164 of the Criminal Procedure Code. And lastly, we have discussed the concept of the retracted confessions. I think we have got the clear concept under this topic. Okay, that's all.